Hello, my name is Philip Kedge and I am the Director of the McKenzie Friend UK network. So, are you at the receiving end of conflict and acrimony in child arrangements? It is very common that clients come to us seeking help who have had false allegations made against them and their personalities and parenting abilities literally demonised and drawn through the mud. If you're in this position, then nearly always the biggest mistake is to respond in the same way. Particularly if you are the person seeking residence. Such a response can significantly hinder and damage your own case. When mud is being thrown at you, it is a very natural instinct to both defend yourself and to then throw accusations and assertions back at the other side. However, by doing so, it only informs CAFCAS and the courts that both parents are at war, that there is little likelihood of positive co-parenting in the foreseeable future, and they are likely to conclude that the children are being subjected to emotional harm. You responding inappropriately is likely to increase the chance of you ending up in a contact centre under supervised contact, and to significantly delay any progressive contact arrangements. This, of course, is exactly what the other side may want, and you have fallen into that trap. I urge you to consider that the best response is initially to do nothing, and not to respond in defence or attack. You need to absorb the mudslinging and the character assassination, and to rise above it. You need to demonstrate your wish to engage in positive co-parenting and to move forward in a balanced and measured way. You need to demonstrate good parenting and not harm your children by placing them in the middle of a parental war. If you respond appropriately, then you are much more likely to gain the regard and attention of both CAFCAS and the courts in moving forward to gain appropriate access to your children. Now, there may of course be times that serious allegations are made that CAFCAS and the courts will have to consider under what is known as Directions 12J. And there may have to be fact-finding hearings, but these are relatively uncommon. Very serious issues are managed by the court, and you'll get every opportunity to reasonably respond. But the secret is to work within the framework of the court to resolve such issues and not to knee-jerk with emotional responses that may harm your case. Acrimony, conflict and mudslinging is very common, and the courts have a well-worn procedure to deal with it. Don't you get involved in doing the same thing. Very often, and sadly, we find that those who engage in acrimony and conflict are often legally represented. But please consider that many lawyers, particularly family solicitors, operating under their clients' instructions will adopt an adversarial position. After all, arguably, the very existence of family lawyers as a business model depends on there being conflict. It pays their wages and keeps their businesses running. My advice to you is don't play that game. Don't feed into that conflict. Don't put your children in the middle of a war. If you are at the receiving end of conflict and acrimony and feeling angry, lost and frustrated, then give me a call today on 01 420 370 770. We can mentor and support you through it and stop you making the mistakes that so many people make. I look forward to receiving your call.